I hear that we are live. So we had a few last-minute technical difficulties, so I am coming in through a phone as opposed to the Zoom video and audio, so I hope everyone can hear me. If you have any questions during this session or if there's any technology issues that are going on, please email as this is going on to Doris. You'll see her email address along the bottom, and we'll see that come up and communicate to us. So hopefully you can hear me. We've been dealing with a few technical issues. Thank you everybody for joining us today. I guess, apologizing for technical issues is how these things are going. It's how we begin every CLE these days. I want to first start by welcoming and thanking Courtney Amelung from Shaw and Rosenthal. She'll be joining us as well and presenting today. She is an associate attorney at Shaw Rosenthal. As many of you know, that's a management side labor and employment firm. She practices in Baltimore and represents employers on a wide range of employment issues in federal and state courts and agencies. She does EEOC work, MCCR in the Department of Labor, and also does risk management for employers, such as doing handbooks and personnel policies. So welcome, Courtney, and thank you for presenting with me today. So as many of you may know, there was a flurry of legislative activity that occurred right at the end of the session's early adjournment. They managed to pass over 600 bills in just 3 days before that early adjournment. And among those are a few significant employment bills, and we're going to cover those today. These became law back in May, on May 7th, and they're going to go into effect on October 1, 2020. I'm going to begin with the mandatory state WARN Act requirements. This is probably one of the more technical laws to cover, so there's a lot to it and a lot to pay attention to. While we did have a mini WARN law in Maryland, it was always voluntary before this. So it is a major change that now there are mandatory requirements with enforcement mechanisms for it. It used to be voluntary 90-day notice. It's now mandatory 60-day notice. So this is a big change, and it varies significantly in places from what we're already following with the Federal WARN Act. So if we can go one slide up. So this is, this came about, and why this, if we can move to the next slide. So how did this come about? This is part of the efforts in the state to respond to the current climate. The timing is not coincidental. We have many employers who are facing really tough decisions right now with the pandemic. So this was not, this was timed specifically because we know employers are engaging in layoffs and considering whether they have to shut down operations in places. So this is part of the stabilization efforts that the legislature made in response to the pandemic. So there's a lot to take in here. I tried to include the basics in the slides, but there's so much. So certainly email questions to me, and I'm happy to work them in, or we can come back to them at the end, but there's a lot to it. One of the biggest things that's going to open the eyes of all of us who've been dealing with the WARN Act federally for all these years is this one applies to 50 or more employees, employers of 50 or more employees operating industrial, commercial, or business enterprises. So there is a requirement, it's not on the slide, that they have to have been operating for at least 1 year. So this isn't meant to scoop up the brand new businesses that didn't make it the year. But 50 is a big difference from what we've seen federally, which has the 100 or more employee requirement. There are some exceptions. Again, I didn't want the slide to be just a huge amount of text, but if the reduction is happening solely due to a labor dispute, it's not covered. As we all know, the Federal Act has some coverage for certain public or quasi-public agencies, depending on certain things. This one specifically and expressly exempts state government or political subdivisions of the state government, so they aren't covered. Customary seasonal factors that cause layoffs, those are not covered. A bankruptcy filing is also going to be an exception to all of this. There are some exceptions we're used to seeing federally, though, that are not in the Maryland Minnie-Warren Act. So, for example, and this one's very relevant right now, there's no natural disaster exception, which during COVID is very interesting. So there's, we have that federally. You don't see it here. There isn't one for unforeseeable business circumstances. Not here, even though we're used to dealing with that in the Federal Act. So the exceptions are a little different than what we're used to. As we know federally, if the nonprofits meet the number of employee threshold, they're covered. Same thing with the Maryland State Act. There's nothing excluding nonprofits from it. All right, so on the next slide, talk a little bit about, how do we figure out how do we count the 50 employees? There are certainly some that do not count. And this is going to sound very familiar to those of us who've been dealing with the Federal Act. Those who average fewer than 20 hours per week do not count toward the number of 50. And there's a formula right in the Federal Warren Act that assesses the average hours worked, and that's where I would go and use that same formula, for assessing who's working 20 hours per week. I'd use the federal formula there. It also doesn't count those who have worked for the employer for less than 6 of the preceding 12 months. And again, that's all the detail you get in our state law, but if you look at the federal law, they calculate that number 60 days before the RIF. I would do the same thing here. As I have this slide, one thing you want to remember, though, that I see frequently people get messed up with is that even though these employees don't count toward the 50, these ones who are working part-time or, less than 6 months of the preceding 12 months, even though they don't count towards your number of 50 total employees, they do get notice. And I see that get messed up all the time where they do a count, these people weren't counted, and then they don't get the notice, which would be a violation. So keep in mind, this is just how to figure out the count for coverage, but it's not a list of who gets coverage and notice. So on the next slide, the big term that we're dealing with here is reduction in force. It's a defined term in our Minnie-Warren Act, and covered employers have to provide 60 days written notice. On the next slide, I give you some ideas of how to frame this. We're dealing with the term reduction in operations. This is going to be very similar to the term you're used to from the Federal Warren Act of mass layoff. I have a question come in. Somebody questioned. I'm going to get to that and what the DLR website says. That's a great point. And I can go to that now, but it is correct right now that the DLR website is saying that it is not going to enforce these until they're able to develop the required regulations and guidelines. They're planning to roll those out for public comment in November 2020 with implementation. I think their goal is April 2021. There's no deadline in the statute. So the question was, with that, how are you advising your employers as to compliance with the law until DLR says it will be enforced? Good question. I'm telling them exactly that. I'm advising them about the law. I'm telling them what it is, what it requires, but I'm also letting them know, look, DLR says it's not going to enforce it until these regs are out there. I think there's, and we're kind of moving ahead, and I'll get back to it, but there's no private right of action in this statute. You know, a little bit of relief on the employer side of advising people, but I'm going to be advising my clients to comply, but know that there's likely not going to be a lot of enforcement mechanisms in place until early spring at the soonest. Okay, moving off that question, when you look at you know, the mass layoff versus reduction in operations, and mass layoff is that term we're so familiar with from federal law. The definition, and I've put that right in the slides so everyone has that, the reduction in operations is a relocation of a part of an employer's operation from one workplace to another existing or proposed site. That's one way. So we still have the relocation, similar to federal WARN, or the shutdown of either a workplace or a portion of the operations of a workplace that reduces the number of employees by the greater of at least 25% or at least 15 employees over any 3-month period. Now, one thing you're not seeing in reduction in operations is you're not seeing construction sites. They are not going to be covered. So if you've got a construction site that's going up, coming back down, not covered. Temporary workspaces, something that's just going up and always expected to be temporary and come back down, not covered as a reduction in operations. And on the next slide, in the next few slides, I've tried to give you some examples of how the Maryland laws are going to differ from the federal laws. For those of us who have practiced for a long time with the federal WARN laws, I wanted to sort of highlight for you areas that are different. And keep in mind, you're going to have to comply with both if your employer is covered by both. So one example is just Maryland's threshold requirement for a reduction in operations is a 25% reduction or 15 employees. We're used to federal law that is a third reduction to 33% or 50 employees. So Maryland is going to capture a whole slew of reductions in operations that wouldn't be covered by federal law. Now, if they're also covered by federal law, you need to comply with both, but you are now going to have situations where the Maryland law may bring someone in where you have no obligations under the federal WARN law. So that's one big difference. On the next slide, I point out an obvious one, the coverage issue. 100 employers for federal law, and Maryland's is 50 or more. So again, a number of your clients on the defense side who have never dealt with WARN Act obligations are going to have to be looking at it. Much smaller employers are getting implicated into this new law. And on the next slide, again, another difference, and I think this one is interesting. It'll be interesting if it stays this way. On the relocation prong, and we're familiar with the federal, the idea that they're going to move your workplace location, we don't have in Maryland's law a minimum distance trigger. As we know in federal law, it's 100 miles from the prior location. As this is written in Maryland, there's no minimum distance. So moving down the street could trigger this. So that's a big difference that we're not used to. There's also no minimum number of employees affected on the relocation prong, right? So if you are relocating a work office that only has a couple of employees there, you know, it can affect any number of employees on the relocation aspect of it. So, and this is going to be similar for those of you who watch what happens in other jurisdictions, exactly what's been going on in California, for example. You know, a site with, if you have the overall number of employees that brings you under coverage, if you're going to then move a location that only has 2 employees, you're still going to trigger that relocation provision. So Maryland's going to be just like that. On the next slide, I gave you the actual list from the statute of who the written notice must be given to. And I want to talk about some of the differences that you'll see here. All employees subject to the reduction, we're used to that. Any exclusive representative or bargaining agency, this is going to be your unions. Obviously, they're going to get this. State agencies, the Maryland Department of Labor, the workforce development. I've listed some of the agencies you have to give notice to. And finally, the one we're very used to, because this is the one with bite in the federal law, all elected local officials in the area of the affected workplace. As federal law requires only the chief elected official, Maryland is saying all local officials in your jurisdiction, and it isn't defining jurisdiction. So that will be an interesting, as you have to figure out who are the, all the local officials who are elected in whatever your jurisdiction is. Not a lot of guidance on the employer side of that one. And even though it's not in the slide, I do want to just raise a point here for those who, again, have been dealing with this for a long time. All of the federal WARN, the Maryland mini WARN, all of this is all on top of the already existing obligations in Maryland to give notice to unemployment insurance. As we know, and those are completely different. The unemployment insurance, I think it's 25 employees in more than, who are laid off for more than 7 days. You have to give notice within 48 hours to unemployment. They count employees differently for that. Everything's different about that law, but this has not superseded that law. That's still in place. So you really could have a layoff, a reduction in operations that implicates the federal WARN law, Maryland's mini WARN law, and also the already existing obligation to inform unemployment. On the next slide, I give you a checklist of the contents of the notice. The name and address of the workplace. Again, you're going to see requirements, they're similar, but a little bit more extensive than what you see in federal law. For example, in federal law, emails aren't included. Here they are. Your supervisor's contact information, they're going to want name, telephone, email under Maryland, which is not required under federal. The rest of it in this list is going to be very familiar to those of you doing federal WARN work. Statement explaining whether the reduction is permanent or temporary, whether they're expecting the workplace to shut down, and the date when the reductions are going to start. So those are your contents. The next slide talks a lot about, and I think there's a lot to dig into on this next slide, which is, what if an employer violates these requirements? As I mentioned before, the law does not specify a private right of action. As we know, the federal law, that's it, right? The federal law is completely enforced by private lawsuits. This one is silent, whether or not there's a private right of action or do just claims go to the Maryland Department of Labor. So that part is not as clear. As I mentioned in response to the question earlier, there is a requirement written right into the statute that the Maryland Department of Labor has been directed to develop regs and guidelines on this law, and they are stating right on their website, if you look at it, that no enforcement is going to happen until that occurs. And again, I gave the timeline for that, so we're probably looking at spring by the time this goes through public comment and they get implemented. So I give you the civil penalty structure here. What if an employer violates Maryland's requirements? You can see the civil penalty of up to $10,000 per day. This gets assessed by the DOL. This is discretionary. It's not a mandatory fine. And they do give the factors that will be considered in determining the appropriate penalty. One of them is the gravity of the violation. Another is the size of the business. Good faith efforts by the business will be considered. And then history of prior violations is also going to be considered. And all of these penalties do come with Maryland, notice and a right to an administrative hearing in Maryland. So, these fines can be assessed, discretionary, and there is some due process in place for clients who've had these penalties assessed against them. One of the most interesting things to me in what the Department of Labor has been directed to do as far as their regs is they're also required to put together regs about continuance of benefits. And they expressly list the benefits that they're supposed to address, and expressly in this direction are health, pension, and severance. I was fascinated personally to see the severance mentioned. I don't know if anyone pays attention to other jurisdictions, but New Jersey just became the first state to mandate severance obligations in their Minnie-Warren Act. So to me, when I saw that severance was listed as something for the Department of Labor to address, my antennae went right up, because if they have to put guidelines on there, are they going to be considering a mandatory severance provision? They won't be the first state to have done that. So, an extra reason to pay a lot of attention to what comes out of DOL, Maryland's DOL in November, to see what they're going to do with that, because certainly mandated severance in Maryland would be a whole new ballgame on every side of the equation here. So there's no guidance given on these benefits, just that they have to come up with guidelines on them. There's nothing saying, oh, these 60 days, you must provide them, nothing like that. So we have no idea what is going to come out of the DOL on these. One other thought I've had is just something to watch what happens. I don't know what they're going to do with these guidelines, but I have a hard time thinking what they might do that wouldn't potentially have ERISA preemption issues. So if I'm on the defense side of this and get some huge mandatory severance obligation assigned to me or something, I think there's going to be interesting ERISA preemption arguments when they start touching benefit plans, if they indeed mandate anything there. For those of us who deal with that, we can all imagine that that's going to be an interesting issue to navigate. Another thing I noted here, the difference in the penalties, $10,000 per day under Maryland, it's $500 under the federal statute. So huge difference for our clients out there. And Maryland is giving the penalties for failure to provide any notice at all. And we saw the long list of people who get notice. Whereas in federal, we know it's the elected official. And that's where the penalties come in. So, again, much larger implications for employers out there. Well, it's not on the slide. Compliance can be compelled, so it's not just penalties. They can compel compliance with the notice provisions. The statute is silent on whether it is per employee or per violation. It doesn't state one way or the other. And also keep in mind, there's not going to be any set-off arguments here. You have to comply both federal and state, which means you could get both penalties assigned to you. So it could be federal on top of the Maryland Minnie-Warren penalties. DOL is also required to put together guidelines on how to access, how employers can request assistance if they need it. That's going to come out in November's public guidelines for public comments. So there's a lot happening on the enforcement side of this and things to watch, and I think a lot of interesting issues down the road for those of us to dig into. That covers the Minnie-Warren Act. I know it's dense. If anyone has any questions, I'm happy to answer them now or at the end and revisit it, or feel free to email me if you have any questions, because I think there's a lot for us to dig into here, a lot of unknowns for everybody, for the employees, for employers, and what's going to happen. So at this point, I'm going to turn it over to Courtney for, I think, what are definitely more dazzling topics than notice of layoffs, with a really interesting history, as most of us know. So Courtney, I'll turn it over to you.
Thank you, Joyce. So we'll start first with the new hair texture and hairstyle discrimination ban. So as Joyce implied, there's a really interesting history or background to this law in Maryland and these new laws that are being passed really across the country. But the need for protection against hair texture and hairstyle discrimination really entered the political spotlight and the national spotlight back in December of 2018, when a white referee forced a New Jersey high school student who was of mixed race, but forced him to cut off his dreadlocks or forfeit a wrestling match because they could not find an appropriate covering for his hair. And so the student ultimately went on to win his wrestling match. However, a video of his hair being cut off by a trainer of his with scissors went viral on the internet. And in the wake of public outrage over this incident, several states and local jurisdictions began passing laws prohibiting discrimination in employment and housing and education based on hairstyles typically associated with race. And these laws have really been passed in response to a growing concern that people of color, particularly African Americans and persons of African descent, are frequently targets of discrimination based on their hair and their hairstyles. Particularly rules or policies that restrict certain hairstyles that are typically associated with persons of color, whether implicitly or explicitly, often perpetuate racial stereotypes and racial discrimination in the workplace and elsewhere. And so this legislation that's been being passed across the nation really is frequently referred to as the Crown Act, with Crown standing for Creating a Respectful and Open World for Natural Hair. And California was actually the first state to pass this legislation back in January of 2019, and it was signed into law in July of 2019. Thereafter, other states, including New York, New Jersey, and of course, Maryland, among others, passed similar legislation. So if we could go to the next slide. Thank you. So the Maryland General Assembly passed a version of the Crown Act back in March, prohibiting hairstyle discrimination in employment, housing, and public accommodations. Interestingly, the House and the Senate initially passed different versions of the bill. The Senate attempted to add a provision that would have provided that employers could establish and require employees to adhere to reasonable workplace grooming standards. However, some people believe that weakened the legislation, and the Senate ultimately approved the House's version of the bill without this additional language. But so what the law does is it amends the definition of race in the state government article of the Maryland Code. Specifically, it expands the definition of race to include traits historically associated with race, including hair texture, afro hairstyles, and protective hairstyles. And the Act further defines protective hairstyles to include braids, twists, and locks. And as with the state's prohibition against discrimination based on other protected categories in the workplace, this law similarly applies to employers with at least 15 employees. Next slide, perfect, thank you. So as usual, Montgomery County was actually ahead of the curve on this, and back in November of 2019, the Montgomery County Council voted unanimously to pass a version of the Crown Act. And actually in doing so, Montgomery County became the first local jurisdiction in the United States to pass such legislation. Like the Maryland state law, Montgomery County's law expands the definition of race to include immutable characteristics associated with race, including hair texture and protective hairstyles. And again, protective hairstyles is defined to include braids, locks, afros, curls, and twists. And the Montgomery County law became effective on February 6th of this year. For those of you familiar, pursuant to the Montgomery County Code, it applies to any person employing one or more individuals in the county. I also want to mention that the Baltimore City Council is also considering a bill that would ban hair and hairstyle and discrimination. It's currently entitled Banning Discrimination Based on Hair Texture and Protective Hairstyles. It's not yet been passed, but again, similar to the Montgomery County law, would apply to any employer employing one or more persons. For those of us on the management side, just kind of from a practical perspective, what this means for our clients is that they really should be reviewing their grooming and appearance policies to determine whether they target hairstyles that are traditionally associated with people of color, or whether they disparately impact people of color. And they should be making sure that they're applying any such policies in a race-neutral and uniform fashion. Employers should also be revising their other policies, such as an anti-discrimination policy or anti-harassment policy, to make sure that they are including protection for natural hair and hairstyles. In addition, we should be advising our clients to update their diversity and anti-discrimination training, particularly as it applies to management level employees, to ensure that such training is covering discrimination based on natural hairstyle. And as always, employers should be mindful of any other physical or cultural characteristics which could be associated with race, and make sure that they're developing and implementing their workplace policies accordingly. Okay, we can go on to the next. Thank you. So next up, we actually have two revisions to Maryland's Equal Pay for Equal Work Act, which was passed in 2016 and expanded Maryland's prohibition against discriminatory pay practices by prohibiting gender-based pay discrimination. And so this year, as I said, the Maryland General Assembly made two amendments to that law. The first bill amends the law to prohibit an employer from taking adverse employment action against an employee for asking about the employee's own wages. And this bill was enacted to correct somewhat of a silly loophole that had existed previously in the law. So before the amendment, employers were prohibited from retaliating against an employee for inquiring about the wages of other employees. And this amendment simply extends those protections to circumstances where the employee is inquiring about his or her own wages, which makes sense. Next slide. And so the second and actually more significant amendment to the Equal Pay for Work Act adds a requirement that employers provide a wage range for a position to applicants upon request, and also restricts what an employer can ask about an applicant's wage history during the hiring process. And so the purpose of the amendment is to address the long-term impact of the gender wage gap that can be perpetuated, oftentimes unknowingly and unintentionally by using or relying upon a applicant's wage history to set the wage rate at the time of hire. So if we go to the next slide, we can see all of the number of obligations and prohibitions that this law imposes upon employers during the hiring process. So the first thing that it does is it requires an employer to provide the wage range for the position in question upon an applicant's request. It also prohibits an employer from relying upon an applicant's wage history when in screening or hiring or determining wages. It prohibits an employer from asking for an applicant's wage history, whether that's orally, in writing, through the employee, through an agent, or from a current or former employer. It also prohibits an employer from retaliating against or refusing to interview, hire, or employ an applicant who did not provide their wage history or who requested the wage range for the position in question that they're applying to. Notably, the law acknowledges that an applicant may voluntarily provide their wage history during the process. And the law also provides that after a conditional offer of employment has been made, the employer is able to confirm and rely upon the wage history voluntarily provided by the applicant in order to support a higher wage offer than was initially offered, so long as the higher wage does not create an unlawful pay differential based on sex or gender identity. And so if we go to the next slide, there are penalties for violations of this law. So applicants can report violation to the Department of Labor's Commissioner of Labor and Industry, which has responsibility for enforcing the act. The commissioner is obligated to issue an order compelling compliance if it determines the employer has violated any of the requirements or obligations in the law. In addition, the commissioner has the discretion to issue a letter to the employer compelling compliance for a first violation. For a second violation, it can impose a civil penalty of up to $300 per applicant. And for each subsequent violation that occurs within a 3-year period of a prior violation, the commissioner can impose a civil penalty of up to $600 per applicant. And so in determining the amount of the penalty, the commissioner will consider the gravity of the violation, the size of the business, the employer's good faith, and the employer's history of prior violations. If the commissioner decides to impose a civil penalty, that penalty will be subject to notice and hearing requirements. And so again, for those of us on the management side, you know, from a practical perspective, we should be advising our clients to create formal wage ranges for all of their positions so that they can be provided if requested by an applicant. We should be revising our employment applications or any hiring materials, interview prompts, things of that nature to remove any questions about salary history. And as always, you know, providing training to managers, to hiring personnel such as recruiters, and to human resources personnel is obviously critical so that they can be aware of these new restrictions and know what they, you know, can and really cannot do now, given this new law, you know, during the hiring process. And so that's all that I have on my on these additional 3 laws. Happy to take questions if anybody has questions for me or Joyce at this point. All right, well, if there's no further questions, we can go ahead and sign off. You know, feel free to reach out to either me or Joyce afterwards, and we can follow up with any questions you might have then. But we appreciate everybody for their participation, and hope you found this informative. So thank you all again for tuning in, and thank you for dealing with our technical difficulties this afternoon. We appreciate that as well.